All right, good morning, ladies and gentlemen. We are going to commence with our Fulton State All-Purpose Calendar. This is a list of criminal matters in which we have cases that have already been accused, bonds have already been set, and we're going to have several cases from different locations at the Fulton County Jail, including perhaps other locations as well. If you are a defendant accused of one or more misdemeanor offenses, please remember that you have a right to remain silent about the facts of your case. Anything that you choose to say when we address your case, your statements will not only be recorded, but also used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one would be appointed to represent you. All right. Miss Grace, do we have the, Miss Helen, if you can help me out, have you all given us your list of cases and how you intend to proceed? I never know.
I believe PD Finley emailed the announcements this morning.
Yes, Judge, I did email them. Did you not receive?
Did you not receive it? We can forward it to you, Judge.
Yes, please. If you just
Yes.
forward me one list, thank you.
I will forward it right now, Judge.
Okay, thank you. All right, and Miss Grace, we all set? Okay, good.
Yes.
All right, let's begin with, good morning, folks at the jail. I have South Annex Courtroom 2 and 7 South. Deputy Milton raised her hand first. South Annex.
Good morning, Your Honor. Good morning to everyone. We have before you position 20, Ms. Satterwhite.
All right. And Miss Helen, how are we proceeding on Miss Satterwhite, position 20?
That would be a negotiated plea, Your Honor.
All right, thank you. Ms. Shiana Satterwhite is case number 22 CR 002-675E. Ms. Satterwhite's been accused of criminal trespass and from a March 14, 2022 incident. Ms. Satterwhite, we're going to have a plea hearing. May I place you under oath?
Yes.
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. All right, Miss King, is it?
Yes, good morning.
Good morning. What's the offer, please?
It is 12 months to serve, time served 100 days with the balance suspended and a stay away from 3100 Washington Road in East Point.
Okay, thank you. Miss Helen, do we?
Yes, Your Honor. We stipulate to the factual basis venue, and ID, and we do accept this plea.
All right. Ms. Satterwhite, have you consumed any medication or alcohol recently?
No,
And have you understood the proceedings so far?
yes,
And are you satisfied with your attorney?
yes,
And has she explained to you that if you decide to take this guilty plea, that you would have to give up your right to have the opportunity to have this case in a court of law before a judge or a jury, to be able to confront your accuser, challenge the state's case, present your own defenses, and have the state try to prove the charge against you beyond a reasonable doubt?
I choose guilty.
All right, so do you choose to give up your constitutional rights and plead guilty?
No,
In order to plead guilty, that means that you're admitting to all the elements of the state's case
yes,
and that you are choosing to not go to trial for this case. So
okay,
again, I'll ask you, if you decide to plead guilty, do you agree to waive and give up your constitutional right to go to court, have a trial in front of a judge or a jury?
no.
Miss Satterwhite, she's just asking you if you want a jury trial. Do you want a jury trial? We talked about that. Do you want a jury trial?
No,
All right. Do you want a trial in front of a judge?
no,
All right. Do you agree to give up your constitutional right to go to court and challenge the state's case and have the state try to prove the charges against you beyond a reasonable doubt?
no,
All right. Do you understand the question?
yes,
I don't believe she understands the question, Judge.
All
Miss
right.
Satterwhite, she's asking you if you give up your right to have that jury trial. Are you okay with giving up your right to have that jury trial?
yes,
How do you plead, Ms. Satterwhite?
plead guilty.
Accept your guilty plea, your sentence is time served, and you cannot return to 3100 Washington Road in East Point, Georgia.
Okay,
All right? If
yes,
you return to that location, you'll be arrested again, and we get to do this all over again.
okay,
All right, thank you.
thank you.
Thank you, Judge.
They said,
7 South, who do we have?
Number 19, Mr. Robinson.
All right, thank you.
And Your Honor, that is going to be an arraignment only.
Okay, Mr. Ty, and do you waive a reading of the accusation?
I do, Your Honor.
Thank you. Mr. Tyrone Robinson is 19 CR 006-138Y. He's been accused of simple battery, domestic violence, and obstruction of an officer from December 24th, 2018. Mr. Robinson, you've been advised of your right to remain silent, and your attorney is Ms. Helen. I understand that you'll be entering a not guilty plea to the charges brought against you. If you decide to enter such a plea, then your case will be scheduled for trial, during which time the prosecution, that is the state prosecutor, would have the complete burden to prove the charge against you beyond a reasonable doubt. If the prosecutor succeeds, you could be convicted of one or more of these charges and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. How do you plead, sir? Your case has been arraigned and it's going to be further notice for trial. Thank you.
Thank you, Judge.
Courtroom 2, who do we have, sir?
We're gonna start with the competency with position 14, Mr. Sidney James,
Slander my name too.
and he's going pro se.
Sue Juris.
Could you repeat the name again, please?
Sidney
Sidney
James,
James.
I'm sorry, if one person could speak.
Sidney James.
James, thank you. All right, is Mr. Derek Howard on the Zoom as well? All right.
Not yet, Judge. I'm texting him right now. I believe he may be in
I
another.
actually just called him. He said he was gonna log in,
Okay.
Thank you.
but Your Honor, we have to handle this.
Yeah, I reserve all rights to
All right, Mr. James, I'm going to wait for one of the attorneys who handles competency or. well,
Ain't nobody representing me. Y'all already know that, you know what I'm saying?
Understood. I'm not calling that attorney to represent you.
Well, my thing is y'all slander my name. Ain't no incompetency. Y'all incompetent of the law.
It's just the name of the calendar. It's no reference to you.
Just making sure.
Okay,
And for the record, on the record, and let the record show, I challenge the jurisdiction of the court.
okay. Let me just remind you, sir, that you are charged with obstruction of an officer and criminal trespass. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. So please refrain and do not interrupt me again. Please refrain from making any comments about the facts of the case. Otherwise, you could end up incriminating yourself.
Well, y'all already incriminating yourself.
You have a right to an attorney if you cannot afford one. We do have attorneys from the Public Defender's Office who will
You already know I'm
represent
not
you.
using no attorney, you know what I'm saying? Because y'all, that's in conflict of interest.
One more time you interrupt me, we will address this case next Thursday. If you choose to waive your right to counsel, then you will be responsible for understanding how the law surrounding your criminal case, as well as the rules of criminal procedure and how they apply to the facts of your case and to your personal situation. Any legal decision you make, you will be responsible for understanding how it impacts upon your personal situation, whether you have any other open cases, as well as your residency or any particular issues with your job or occupation. Given this information, would you like the assistance of the public defense attorney who could advise you on the various laws and procedures and how it applies to your situation? Or would you like to proceed self-represented, that is, representing yourself and be responsible for the outcome of your own decisions? You may respond. Mr. James, do you want the assistance of an attorney, or would you like to waive your right to counsel and represent yourself?
I told you I'm sui juris. I'm not using none of your de facto attorneys and all that stuff.
I'm just simply asking you whether you want to represent yourself, or would you
You
like?
already know that I'm representing myself. I don't know why you keep asking. You know, every time I met you 2 years ago, you know what I'm saying? You in bad behavior.
And if it, you know, I'm just going to play dumb, and because I just need to be absolutely sure.
Can't play dumb. Judges are sworn to obey the Constitution irrespective of opinion and the consequences, constitutional rules over statutes. For the record, on the record, let the record show.
You've been accused of, and Mr. Howard, is he on yet?
It don't matter. Just go further.
No, Judge, he's not on, but I've reached out to him.
And y'all dealing with high treason too. And I want all takes reserved too for one military court.
All right.
Your Honor, I just
Yes.
spoke with ASG Walker, who will be handling these cases, and he's asking for a 1-week reset to 8/18, if that will please the court.
Okay.
I'm putting charges on y'all too, under 42 and 18 United States Code, because y'all dealing with serious charges out here too. And we see the video.
So, Mr. James, we are going to do this very, very orderly. You don't get to just chime up and speak anytime you please.
What we doing with conspiracy against rights under color of law?
So this is what the rules of criminal procedure are. This is a plea and arraignment calendar. So a plea and arraignment calendar is where you would either consider a plea offer from the prosecution and decide whether you would like to accept it and waive your constitutional rights to a trial, plead guilty or no contest, and accept the recommended sentence. In the alternative, you have a right to plead not guilty and demand your right to a trial before a judge or a jury. So this is what a plea and arraignment calendar is.
Well, it's been a year, you know what I'm saying? So
you have been charged with obstruction of a law enforcement officer and criminal trespass. These are misdemeanor charges.
Violation of due process.
All right. So,
Misdemeanor treason.
understood.
Yeah,
So,
conviction. Y'all have no
since-
conviction. Now, let me ask you this. Did y'all receive my habeas corpus? I filed my habeas corpus March 15th. Y'all didn't respond back. Under United States Code Title 2243, y'all got 20 days to respond back. And I got the share mandamus right here too. And y'all ain't respond back. And it says right here, it says, Title 28 of the United States Code acknowledge that it is not the responsibility of the petitioner to know by what claim or authority the state act, but that the petitioner may inquire as to the cause of the restraint by habeas corpus. 28 United States Code 2243. A court, justice, or judge tribunal entertaining an application for a writ habeas corpus shall forthwith award the writ or issue an order directing the respondent to show cause why the writ should not be granted.
all
Then
right, so that's what we're gonna
when
do
the-
then,
when-
Mr.
when the
James. We're
person-
going to have a show cause hearing.
No. It says when
That's
the
gonna
person,
be scheduled for August 18th.
when the person
And you currently
holding the
have a
prisoner neglect to answer
$2,500 bond.
said
Thank you,
habeas corpus
deputies.
within the
This
federal
concludes the
rules
case.
procedure
Okay, come on.
55.
Let's go, James.
I will be putting charges on you too.
Get your stuff.
All right, just make a note, Ms. King, that position, Mr. James' case, position 13 and 14 and 15 and 16 are all reset to August 18th for a show cause hearing as to why he should not be released on bond.
Yes, Your Honor. Thank you, Your Honor.
Thank you. Okay, moving on in courtroom 2, Francois, may we have your next case?
And Judge, I did forward that email to you. Just want to make sure you got it.
Oh, yes, I did. Thank you.
Calendar, Judge, we're doing position 18, Mr. Robinson.
All right. Mr. Robinson is Rico. This is Rico Robinson, case number 22 CR 004-941J, who was accused of loitering or prowling on July 26, 2022. Mr. Robinson, you've been advised of your right to remain silent, and your attorney is going to be Mr. Finley, is that? Oh, no, that's going to be Miss Helen, sorry. And this is going to be a negotiated plea. May I place you under oath for purposes of the plea?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. King, what is the offer, please?
Yes, Your Honor, it is 12 months to serve 22 days, credit for time served 11 days with the balance suspended, and a stay away from Mr. Rico Robinson, 3210 Elkins Street, Elkins in Hapeville.
Is that a particular business or something?
It appears so. Let me see what business it is really quick.
That's all right. I was just curious. It really has no bearing on the case. All right, Miss Helen, do you stipulate to the factual basis, venue, and ID?
I do, Judge.
All right. Mr. Robinson, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with the representation you received from Miss Helen?
Yes, ma'am.
If you decide to enter a guilty plea on this charge, you would have to give up your constitutional right to go back to court and have a trial in front of a judge or a jury to challenge this case. You would not be able to confront your accuser, challenge the state's evidence, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to the charge of loitering or prowling?
Yes.
Your sentence is time served. You'll be released within 24 hours if you have no other cases holding you at the jail. Please remember that you cannot return to 3210 Elkins Street in Hapeville, Georgia. Do you recall that location?
Yes, ma'am.
All right. If you return over there, they will have you arrested again, and then you will have the pleasure of having to deal with me again.
All right, thank you.
All right. So good luck, sir. Thank you.
Thank you.
Next, we have position 2, Mr. Bay.
Denzel Bay is going to be an arraignment and a bond hearing. His case number is 22 CR 004-747E. He was accused of two counts of simple battery, domestic violence from a July 2022 incident. Mr. Bay, you've been advised of your right to remain silent, and your attorney is Mr. Zach Finling. Mr. Finling, do we waive a reading of the accusations?
Yes, Your Honor.
Mr. Bay, you've been accused of these 2 misdemeanor charges, and if you decide to enter a plea of not guilty, the case will be scheduled for trial. At the time of the trial, the state has the complete burden to prove the charges against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the state prevails, you could be convicted of 1 or more of these charges and face a sentence of up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead?
I'm guilty.
Could you repeat your response?
I'm guilty.
All right, your case has been arraigned and it will be further noticed for trial. In this particular case, you received a bond back on the time of your initial appearance, and that was a $5,000 good bond. And your attorney is going to argue for a modification of that bond. Please remember your right to remain silent. Mr. Finling?
Yes, Judge. I met with Mr. Bay yesterday. They are unable to make bond. His family is the only people he has that would be able to help him make bond. He is a 26-year-old man and looking forward to getting out. It looks like the bond order, this case does involve his mom and dad. And originally there was a 10-day, or the bond order has a 10-day stay away, which has since passed, and it's a no further violent contact. I was unable to get a hold of his mom, but his mom did tell him that they would be able to make bond if it was a little bit lower than it is now. He is welcome, it sounds like, back at their house. And he assured me that he would be back to court. He does have strong community ties because he does have his parents, who he's extremely close with, that live locally. So I am asking Judge for the bond to be lowered to a $2,000 surety bond, which would, the breakdown would be $1,000 for each charge, Judge.
All right. I'm sorry, who's my pretrial officer?
Good morning, Judge.
Good morning. Ms. Harrison, any priors on Mr. Bay, please, position 2.
Yes, he has 18 cycles. Last arrest was September of 2020 for probation violation. Underlying charge was burglary and criminal damage to property. He has a 2019 simple assault. No disposition listed on that arrest. 2017 simple battery, family violence, no disposition listed. He has a 2016 failure to appear. Two of those. 2016 simple battery, family violence. Again, no disposition listed on the GCIC. He has a 2017 conviction for burglary in the 2nd degree, criminal damage to property, and theft by taking.
All right, thank you. Mr. Segura, good morning, sir. What is your recommendation?
Good morning. The state would like to retain that $5,000 surety bond, which is $2,500 for each count. As your honor knows, the victims are Denise Mason, his mom, common spelling, and his dad, Mr. Elihu Bay. Elihu spelled E-L-I-H-U, Bay spelled B-E-Y. As your honor knows, in this case, the son was acting erratic and got angry for some reason, and at which point he chased his mom into the bathroom, which he locked herself in. At that point, when Mr. Bay came, the defendant took out his frustrations on him and struck him in the face with an open hand. At that point, Miss Mason got out of the bathroom at which point the defendant struck her in the back of her head. And based on this, Ms. Mason, his mom is 59, and Mr. Bay, his dad, is 81. So we do have concerns about his safety. When we did speak with Ms. Bay back in the CPEP, and when she stated that she not fear defendant and wants to come back, but this is a very bad idea because this defendant has 5 other cases with both his parents and committing violence against him. Back when he was 18, which was in June 19th, 2014, in case 14 CR 006382, the defendant was guilty of simple assault, family violence with both his parents and obstruction, in which he pled guilty. In this case, he lunged at his mom, Ms. Mason, with his bald fist, and also he assaulted his father by telling him that he'll push, quote, his ass to the ground if he doesn't return to his room. Alongside, he also has another case in December 7th, 2014, case 16 CR 013976E, which was a simple battery family violence with his mom, Denise Mason. In this case, this was not possible because he was having a mental health treatment program. But in this case, he was charged with struggling her for closed fist. Back on November the 12th, 2017, 17 CR 025652A. He was charged with simple battery family violence and battery family violence with his father, Mr. Rico Bay. In this case, there's an argument between Ms. Mason and the defendant, in which Mr. Bay got in between them, which resulted in the defendant striking Mr. Bay 3 times in the stomach with a closed fist. Again, because he was in mental health treatment, it was ended up being not passed. But back in July 9th, 2018, 18 CR 007526A. In this case, the victim was Mr. Rico Bay, which was a battery family violence in which a defendant punched him in the face, which resulted in visible injuries. But because he was in mental health treatment, it was being not passed. But then again, we still have another case, July 2nd, 2019, 19 CR 007764G, which was a simple assault family violence with Ms. Denise Mason, in which he was found guilty. And in this case, he had enough further contact with Ms. Mason. So, Your Honor, we'll have a surety bond, and we don't have reduction because, as his previous cases, the not pass shows, he did have mental health treatment. He was involved in a mental health treatment program, but did not prevent further cases of violence of his parents.
Can I speak?
No.
Is that Mr. Bay? I can.
And
Mr. Bay.
Mr. Segura, you may complete.
And we are concerned about the safety of parents. To get an order, again, as noted before, his mom is 59, his dad is 81, and all this has shown that this violence only increased and there's no sign of it actually decreasing and not escalating. And as much as his mom said before, she would want him to come back, but as his case as shown beforehand, this is not a good idea. He'll just come back and the risk of violence will only increase.
Can I speak?
Thank you.
Mr. Bay, please let me speak for you. Anything you say will be used against you, sir.
All right, Mr. Segura, if just one moment of a pause. Mr. Bay, I'm not letting you speak because I'm not going to let you interrupt one person until they complete their presentation. And if there's one more interruption, we are not going to address your case any further. Do you understand?
Yes.
Thank you. Mr. Segura, I do apologize for the interruption. You may proceed.
The state is definitely concerned by the safety of the parents, since the defendant had for almost 10 years committed acts of violence against them, and in which, even though he was in mental health treatment programs for some of those cases, it did not result in any reduction of him having cases of violence with him. And as far as we know, these are only cases in which both parents, well, the ones that did call the police. We are uncertain that how many instances occurred when no one was called. But because the risk of him returning to his parents and causing violence, we won't have that surety bond. Thank you.
Thank you. Mr. Findlay, your client would like to chime in. Would you like to advise him at this point?
Yes, thank you, Judge. Mr. Bay, I would strongly advise you not to say anything. Anything you say will most definitely be used against you, sir. So my best advice would be to let me speak for you.
Right. Ms. Findling, do you have a rebuttal?
I have nothing further, Judge.
All right. Typically on these kind of charges, if an individual has a nominal criminal history record or a remote criminal history record, bonds would not be as severe as the ones imposed in this particular case. What is most concerning about this young man is that there has been no let-up. There have been charges of violence in the context of domestic violence and family violence, domestic violence, at least based on our review in Fulton County from 2014, and consistently in 2015, 2016, 2017, 2018, 2019, and this particular case in 2022. And unfortunately, most of these cases involve family members, and which it reflects that Mr. Bay has established a very high likelihood of reoffending and being a cause of an imminent threat to not only members of his family and possibly to members of the community. And given the violent nature of his past, the court is very disinclined to make any modifications. If there are any future modifications of his bond, there has to be strict conditions put in place with regards to no further contact, with regards to him having perhaps being placed on an ankle monitor, as well as being enrolled in a program that may help him rehabilitate or consider nonviolent rehabilitation measures. By the present time, given his very high likelihood to reoffend and his very high likelihood to pose a threat to at least his immediate family members, the request for a bond modification is denied. This case will be scheduled for trial, and it will be scheduled for trial before the division judge, and that would be Judge Jane Morrison. Thank you.
Okay, you're done. Position 14, Page.
Where do I go? Where do I go, man?
Just have a seat. Just have a seat.
Where?
And Judge, I just want to let the court be aware that his brother and his mother are on the Zoom chat for him as well.
All right. Mr. Findling, please go ahead and advise the family members that this is the bond situation. I'm sorry, Deputy Francois, who's in courtroom 2?
I will, Judge. Thank you.
This is position 14, Mr. Page.
Thank you.
And this is positions 14 and 15, Your Honor.
All right, thank you. All right, this is Rodney William Page. Mr. Page has 2 cases with us today. The first one is 21 CR 003340Y, in which Mr. Page has been accused of battery, domestic violence, hindering a person from making an emergency phone call from June 29th, 2021. The second case is an accusation of simple battery domestic violence from December 6, 2019. Mr. Page, you've been advised of your right to remain silent, and your attorney is going to be Ms. Catrice Helen for both cases. And I'm sorry, Ms. Helen, position 14 and 15.
Yes, Your Honor.
This is going to be an arraignment and a bond hearing. Do
Yes, Your
you waive a reading of the accusations in both cases?
I do, Your Honor.
All right. Mr. Page, in both cases, you have been accused of misdemeanor offenses, which I've already outlined. With regards to these charges, you are legally presumed innocent until the case goes to trial, and the state proves the charges against you beyond a reasonable doubt. Upon your entry of a not guilty plea, the case will be scheduled for trial, where the prosecution would have to present evidence to the judge or jury and try to prove the case of the charges against you beyond a reasonable doubt. If they do succeed, you could be convicted of one or more of these charges and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead?
Not guilty.
All right. Your cases have been arraigned. With regards to position number 14 and position number 15, I just want to check on the bond amounts and see.
It is 5,000 cash for position 14 and 2,000 cash for position 15.
All right. Ms. Helen?
Yes, Judge, can I have pretrial read his
All right.
history, please?
Ms. Harrison? This is positions 14 and 15 with regards to Rodney Page.
Yes, Judge. This is his third arrest. Last arrest was March of 1996 for obstruction of law enforcement officer, misdemeanor in Fulton County. No disposition listed on that arrest. Nothing further to add.
All right, thank you.
Yes, Judge, this is a bond hearing for Mr. Page, who is 53 years old. He is a full-time resident of Fulton County. He's definitely employable, Judge, because he has 35 years as a certified technician. Currently, he's an entrepreneur of his own business, an upholstery cleaning business for the last year. He's a proud father of 2 children. And so let's get to the Ayala factors. I've heard his history. This is not a violent offender. And so, Judge, that's why we're asking for a signature bond or a modification of his bond to signature status. Again, for the Ayala factors, this person is going to come to all of his court appearances. There is a FTA from July 27th. When I spoke to him about that, he had no idea that that notice was for July 27th. In fact, he gave me updated information, which I believe now is reflected in Odyssey, 4396 Rolling Hill Road, Southwest Atlanta, Georgia. And Judge, I also have Miss Jeanette, who is the owner of that property, to speak on a few things specifically with these cases. There's a stay away with these cases, but she is here to state that those 2 individuals from these cases do not live at that residence. So we are stating that there's not going to be any intimidation to any witnesses. Neither one of them are in anywhere near that address. One is in Waycross and one's near Cleveland Avenue. Judge, so we are definitely asking for a bond modification to a signature bond for Mr. Page. I do believe the alleged accusers in this case do have a violent, dangerous history. Miss Jeanette also here is to give a little bit of information about that as well. So that is why Mr. Page is pleading not guilty, and we are asking for that bond modification to a signature bond.
All right, thank you. Ms. King?
Yes, Your Honor. The state would disagree that this defendant is not violent. These 2 cases are violent cases against family members, his 2 nieces, Your Honor. And one of the victims, as Aziz stated, that he's been violent towards them outside of these cases and other females in the family, Your Honor. The first case occurred in 2019 in December, and the victim, Miss Jasmine Page, stated that he drug her by her hair out of her grandmother's room. And she was traumatized by that to the point where she said she saw stars when it happened, Your Honor, due to the violence that occurred to her. The second case happened in 2021. That's Zacavia Page in that case, Your Honor. And she's the one that called 911 because she said her uncle, who's the defendant, punched her in the face multiple times, Your Honor. And the officers even noticed bruising and open cuts on her face and her neck due to the violence from her uncle, Your Honor. The state would strongly disagree that this defendant is not violent. Your Honor, you know the cycles of violence. Victims don't always call the police. So they just decided to call these 2 times, Your Honor, and then we should take it seriously. The bond should stay as set, the 5,000 cash for position 14 and 2,000 cash for position 15. We are concerned for the female members of his family and females and of citizens of Fulton County, Your Honor. These bonds are reasonable under the circumstances.
Judge, we also have his mother, again, like I said, who is the owner of that 4396 Rolling Hill. She can speak to the background, the criminal, dangerous background of these alleged accusers. So I just asked if she gave an opportunity for that, Judge.
I'm sorry, she's going to relay about the alleged victims in this case?
Correct, Judge. As well as stating that they're not at that address any longer. 4396 Rolling Hill Road, they are no longer at that address.
I just need information on who are the occupants of that property. I'm not going to tolerate any statements about the alleged victims.
Understood, Judge.
All right. Ms. Jeanette, if you would like to contribute to this hearing, you need to unmute your screen. I can't hear you, Ms. Jeanette. Can't hear you at all. You have your Zoom on mute. It is a button on your device that you need to press to unmute your audio. All right, Mr. Eric Page, if you'd like to testify first.
Hello, can you hear me, Judge?
Yes, I can. Please raise your
Hey.
right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, it will be.
All right, and what would you like to tell me?
Basically,
Are you in a moving vehicle?
no, I'm in my vehicle, but I'm not moving.
Okay, what would you like to tell me?
Basically, my brother, he's those situations. I know you say you don't want to talk about the victims, but the situation.
And we're not, Your Honor.
Your
so
Honor, the
because
state would
they're
object to
being
any
named
testimony regarding the victims in this case.
Well, Mr. Page,
regarding the case.
Yeah, I'm not going to say
if
anything
you
about
make any comments about the victims, as you can see, there are going to be a lot of objections. So if you have nothing else to say, I'm moving on to Ms. Jeanette.
No, actually, I just wanted to say that my brother, you know, he's a native of Atlanta. He basically provides and helps my mother over at that house where he stays at. Far as I know, it hadn't been any more, you know, occurrences about anything, you know. He's just working every day. He actually has 2 businesses and he works every day. He's a graduate of Emory. I mean, it's just situations. Once they actually go to trial, they'll see what was going on.
And she's unmuted, Judge.
All right,
Yes.
thank you. Thank you, Mr. Page. You may.
You're more than welcome.
Yes, let's go ahead and mute Mr. Eric Page. Ms. Jeanette, good morning.
Good morning.
All right, Ms. Page, if you'd like to contribute, may I place you under oath?
Yes, you sure may.
Thank you. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. I'll be very glad to hear from you about your son, Rodney Page, but I'm not going to address the alleged victims in this case, Jasmine and Zacavia. So if you can just narrow your comments to just about Rodney, I'd be glad to hear it. What would you like to tell me?
Okay, Rodney, I've never had any problems with him from the time he was in high school all the way up to now. I've never had any problems with him. And we stay over there together at the house. It's just the 2 of us, because my home had some damages to it and mold, so I had to move across the street, which we own both homes. And I live over there with him. We have no problems. We work well together. We pay the bills together, you know, basic things like that.
All right, and this is the Rolling Hill Road location?
This here is on 4396, because 4399 was where the work is being done.
All right. And with regards to both locations, do Jasmine and Zacavia live there or have any reason to come there?
No.
Okay, you are their grandmother?
I am their grandmother. Jasmine lives now in Waycross, and Zacavia, she lives, I think, in East Point or somewhere, and she does not come over.
All right. And you understand that if Rodney Page is allowed to return home, that you would have to make an extra effort to make sure that if you want to see your grandchildren, that you would have to go visit them. Otherwise, there will be a problem.
Yes, that's no problem.
All right. Thank you very much.
Okay.
we may mute the screen. All right.
Your
Ms.
Honor,
Hudson, anything else to, Ms. King?
Yes, Your Honor, if I may,
Okay.
the defendant received pretrial bonds in both of these cases, and he failed to appear in both cases, which is why he has cash bonds before you
Understood.
today. Typically, the cases are sent back to the division judge, which issued the cash bond to be further evaluated. That would be Judge Edie, and the state is requesting that you follow that.
I typically do unless the division judge has given the JOs some leeway addressing this, and Judge Edie's division has allowed the JOs some leeway on that. So I'm going to move forward. Ms. Helen, anything else to add?
No, just to recap the Ayala factors, his history, his family has strong community ties, and the alleged accusers are not at that address.
All right, thank you. Mr. Rodney William Page, so I'm very glad that you have family support, but what is not tolerated is the failure to appear in court. Whatever address that you provided at the time when you were in jail back in July 12, 2021, you received a signature bond, which is a privilege, which means that you comply with the court rules and the conditions. And to then plead that you have no idea about your next court date, well, as you can see, this is what happens. If you change address, if you have a difference in your mailing address, if you fail to keep up with the communication with your attorney, that is all on you. So by failure to appear, Judge Edie had issued a cash bond. But currently, given the nature of your criminal record history, the circumstances surrounding that case, these cases, I'm going to modify your bond. On the position 14, where you received a $5,000 cash bond, on the battery is going to be $1,500. On the hindering a person from making an emergency phone call, it's $1,000. That's a $2,500 surety bond. On position 15, simple battery domestic violence, that's going to be a $1,500 surety bond. Your total bond for both cases is going to be a $4,000 surety bond. Look, all conditions remain the same. No contact with Jasmine and Zacavia Page. You are to stay away 200 yards away from them. You're not to contact them in person, not through a phone, not through a computer device, not through a third party like grandmother or a friend, and definitely not to discuss them on social media. Any discussions about them on social media may be attributed to you. If your family members decide to discuss this case on social media about them, could be attributed to you and could also be tantamount to a violation of the bond, which could end up bringing you back to jail. Do you understand? Okay. Now you can return to, I guess, the address that was provided by Miss Jeanette, which I'm assuming is the 4396 location. And if you change your address, if there's a modification, we are the first folks to find out in writing. You would have to come down to the court and fill out a change of address form. Do you understand, sir?
Yes, ma'am.
We will send notices to the last known address on file. You are responsible for making sure that those notices get to you.
Yes, ma'am.
One way of doing that is keeping up to date with the public defender's office if they continue to represent you. But if you do not financially qualify for their services, it is your responsibility to either be on top of the notices or hire a private attorney to be on top of these notices as well.
Yes, ma'am.
No alcohol, no drugs, no illegal drugs, no weapons, and no firearms. You're not allowed to possess any of them. And while you are out on this bond, you will attend and complete a 12-week anger management class at your expense. Do you understand, sir?
Yes.
All right. You may submit the certificate of completion within 6 months from today, and that will be submitted to be filed in the court. And you can say it's a completion of a bond condition.
Yes, ma'am.
Understood?
Yes, ma'am.
All right. Ms. Helen, you will submit the proposed order. The completion of the 12-week anger management program will be concurrent bond condition for both cases. This is not a sentencing bond condition. This is simply a condition of a family violence bond structure.
Understood, Judge. I will be submitting it to Ms. Grace.
All right, thank you.
I have probation number 1, 5 North.
And I will need to briefly speak with him before he's called.
All right, this is the only probation case. So, and this was, I'm sorry, in courtroom
Oh, 5 North.
5 North, all right? Could the host please place 5 North and Mr. Zach Finling in a breakout room, please?
Oh, we could just call them. We got position. We got also have add-on.
All right, if you have Mr. Finling's number or if he has yours, we can go ahead and make that a phone conversation. And I can handle the next case at 5 North.
Add-on 2, Mr. Harris.
What number should I call?
I'll call you. What's your number?
404
Uh-huh.
717
Mm-hmm.
6656.
Okay.
Thank you. All right, we are on add-on position number 2.
Your Honor, if this is Lamar Harris, I was contacted to cover, but I haven't had a chance to speak to Mr. Harris so far. I do apologize.
Not a problem, no apology required. 5 North, do you have another case?
No, we don't.
I'm going to place 5 North and Mr. Owen Lynch. So sorry. Place 5 North and Mr. Lynch in a breakout room. And then once the attorneys have spoken to both the gentlemen at 5 North, we can address the case.
Thank you.
This is position 17, Mr. Richardson.
All right, thank you.
And that's the negotiated plea.
Case, yes.
Yes, it's a negotiated plea, Your Honor.
All right, thank you. By the way, Francois, do you have a Mr. Thornton in the field in courtroom 2? Oh. We're addressing position 17, 21 CR 001042G, State versus Rondrick Sands Richardson, charged with forgery in the 4th degree. Mr. Richardson, you've been advised of your right to remain silent, and your attorney is going to be Ms. Catrice Helen. This is going to be a negotiated plea. May I place you under oath, please? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. You may, Ms. King or Mr. Segura?
Yes, it is, Your Honor.
Okay.
The negotiated terms are 12 months to serve 20 days, credit for time served 10 days with the balance suspended, and a stay away from all SunTrust banks in Fulton County.
Truist.
Thank you, Your Honor.
SunTrust is gone. Okay.
I'll make that update, Judge.
All right.
And yes, Judge, that is our understanding of that plea. We do accept it and we do stipulate to the factual basis, venue, and ID.
All right. Mr. Richardson, have you consumed any medication or alcohol recently?
No, ma'am.
And what?
I'm fully aware.
Excellent. And you've understood the proceedings so far?
Ma'am?
Have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with your attorney?
Yes.
All right. Mr. Richardson, if you decide to plead guilty to this charge, you would have to waive and give up your right to go back to court and have a trial, to be able to confront your accuser, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am. Totally.
How do you plead to 1 count of forgery in the 4th degree?
Yes.
You don't sound so sure. I'm going to ask you again.
Okay.
How do you plead to the 1 count of forgery in the 4th degree involving SunTrust, or now known as
Oh, yes, ma'am. Yes. Yes, it's today.
Your sentence is going to be time served. You will be released within 24 hours unless you have any other cases holding you at the jail. Once you're released, you are to stay away from all banks with the new name of Truist, Truist. They used to be formerly known as SunTrust banks. If you return to any of these banks, they have a right to call the authorities and have you arrested for trespass, which means that you will be back in jail.
I understand. Thank you.
All right, thank you. You're free to go.
Position 9, Hudson.
Do we have another case? Oh, Mr. Bending is back. All right, that's good.
Yeah, I just got back, Judge.
All right. Damien Hudson is case number 22 CR 004-963J. And Mr. Hudson is accused of criminal trespass and damage to property and battery causing substantial physical harm. Is this his only case on this calendar? Yeah. All right. Mr. Hudson, this is from a May 26, 2022 incident. You've been advised of your right to remain silent, and your attorney is Mr. Zach Finley. Position 9 is going to be an arraignment and a bond hearing. Will you wait for reading of the accusation, Mr. Finley?
I do, Judge.
All right. Mr. Hudson, you've been accused of these misdemeanor offenses. You are presumed innocent of these charges. Upon your entry of a not guilty plea, the case will be further noticed for trial. At the time of the trial, the state, the prosecutor, has the complete burden to prove the charges against you beyond a reasonable doubt. If they prevail, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead?
Not guilty.
Your case has been arraigned. You were provided a $4,000 surety bond at your initial appearance, with no further contact, and to stay away from 396 Piedmont Avenue. Ms. Harrison, could you refresh us on his priors, please?
Yes, 25 cycles. Last arrest was June of this year, probation violation. Underlying charges, battery, family violence. He has an additional probation violation also in 2021, 2019, another in 2019. He has a 2018 willful obstruction of law enforcement officer and a criminal trespass conviction in Cobb. He has a a 2015 probation violation. Underlying charge was not listed.
Okay, I think that's good. Thank you.
Okay.
Mr. Finley?
Yes, Judge. I'm asking for a bond modification on behalf of Mr. Hudson. Mr. Hudson does adamantly dispute these charges. As of right now, it is a $4,000 surety, and the breakdown for that is for the criminal trespass and damage to property, $1,500, and then the battery, $2,500. And despite the plea only asking him to do approximately 14 more days, he has zero interest in taking a plea and has every intention of fighting these charges. Leading up to this case, Mr. Hudson was employed at J&J's Waffles, where he held stable employment and hopes to return there once he gets out. He does have strong community ties, Judge. His family lives in Atlanta, and he's extremely close with his grandmother, who he will be residing with once he gets out. And this is I do have a very stable address for him. Additionally, Judge, he is of no threat to Mr. and Mrs. Sessoms. He has no reason to contact them, and has assured me he would stay as far away from them as possible. He is unable to make this bond, Judge, and clearly unable to make even close to this bond. So I am asking for a signature bond, Judge, but if not inclined, would ask for a reduction to a $2,000 surety bond with $1,000 for each count.
You said he has a good address?
Yes, Judge.
All right. Mr. Segura.
Your Honor, we'd like to retain the $4,000 surety bond. Based on the facts which Your Honor knows, the victim's own and Mr. Novia Simmons, Novia spelled Novie, Sessoms, Sessoms, who stated that his daughter, Miss Zenobia Simmons, Zenobia spelled Canovia, Simmons, Sessoms, said that they allowed the defendant, who Mr. Novia Simmons said was the friend of his daughter's, to live in the storage room because he and the defendant and his grandmother were evicted from their apartment. On the date of the incident, Mr. Novia Simmons believed the defendant stole the items from a storage room and she wanted to get the items back. But when the defendant came to the apartment of Ms. Zenobia Simmons, he knocked, but she said that he was acting strange and different. At that point, the defendant broke into the apartment, down in the doorway, in which he attacked Miss Zenobia Simmons, punched her in the face, and got her on the ground, which resulted in her splattering blood. The fight continued until Miss Simmons ended up biting the defendant, which caused him to leave. Aside from this violence, we are concerned because not only about the victim, because they know each other, they're all friends, but they also are concerned about the defendant being a danger to the community. Because based on his record, he does have a long history of violence. Originally from back to 1997, it was a battery charge. 2004, simple battery, which he was guilty of. Alongside, in 2014, he does have a guilty conviction for family body violence, which was a second charge. And alongside, we are concerned him being a fact risk because in 2005 and 2009, he does have 2 FTAs. Alongside, we are concerned by the defendants not following court orders, as back in 2013 and 2020, he does have probation violations. And 2021, he also has a probation violation. So because of that, we're asking to retain the surety bond. Thank you, Your Honor.
All right. Anything else to add, Mr. Finley?
Nothing further, Judge. I can supply that address to the court. I was unable to get a hold of his grandma, but from what he said, that would be a stable address of what he gave me. And it was in Lithonia.
What kind of address is that?
It was a house. It was on Dillwood Crescent, Lithonia, and that is where his grandma lives, who seems to be, that's his family member that he's closest to, and he would be able to live with her.
All right. I'm not certain about the address, considering that the warrant does follow the alleged facts as indicated by Mr. Segura. And I'm not certain about what are the terms of the living arrangement, but under the allegations of the warrant, which are quite serious, I'm going to maintain the same bond. I don't believe that Mr. Hudson is, well, let's put it this way. I believe that Mr. Hudson, based on the allegations of the warrant, may pose an imminent threat to the Sessoms. And until I hear from both of them, I'm not inclined to modify this bond until I have the alleged victim's input with regards to this matter. So this case is arraigned and further notice for trial. Mr. Segura, do you know if the Sessoms have applied for a protective order?
As of right now, we are uncertain about that.
All right, thank you.
Position 10, Mr. Jennings.
And this is a negotiated
Is
plea.
5 North still in conference with Mr. Lynch, I gather? Okay.
Your Honor, I did just speak to Mr. Harris, and I'm just chatting with the ASG just on some finer points, but I believe we'll have a resolution one way or the other very shortly.
Okay, in the meantime, I'll address position number 10, Bernard Jennings. Is that correct? All right. Mr. Bernard Jennings, your case is 20 CR 0000221C. accused of simple battery domestic violence from January 5th, 2020. Mr. Jennings, you've been advised of your right to remain silent, and your attorney is Mr. Zach Finley.
This is a negotiated plea, Judge.
All right, thank you. Mr. Jennings, for purposes of the plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Segura, what's the offer, please?
State's recommended offer is 12 months to serve 365 days. Credit for time served 365 days. Thank you.
All right, thank you. And Mr. Finling, do you stipulate to the factual basis, venue, and ID?
I do, Judge.
All right. Mr. Jennings, have you consumed any medication or alcohol recently?
No, ma'am.
All right, and have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to take this plea, you would not be able to go back to court and have a trial before a judge or a jury, or be able to contest the evidence that's brought against you by the state, as well as give up the right to have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights as well as others?
Yes, ma'am.
How do you plead to one count of simple battery domestic violence?
Guilty.
Your sentence is time served. Thank you.
Back to probation number 1.
All right, we're going to go back to the probation matter. And that is at 5 North, I believe.
Yes, ma'am.
Okay. Mr. Finling, we ready to proceed?
Yes, Your Honor.
Okay. Sorry, to pull it up. Okay. This is State versus Marlon Drew, case number 17 CR 016477D. Mr. Drew is here on a probation revocation matter with regards to this case. The plea was taken back on January 16, 2019, and I'm going to have the probation officer testify as to the reasons why they're seeking a revocation of his current probation. So, Mr. Drew, please remember that you have a right to remain silent. Anything that you say in open court, your statements can and will be used against you. You have a right to an attorney, and your attorney is Mr. Zach Finley. Ms. Middleton, may I place you under oath, please?
Yes, Your Honor.
Thank you. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. All right. And what is the state's position on his probation?
Your Honor, he was sentenced to probation on January 16, 2019 for the charges of suspended and revoked license, was sentenced to 12 months and to pay a fine of $1,320. Your Honor, he has 1 month and 9 days, but we're asking that he receives credit for time served and we close the case.
Any objection from the defense?
No objection, Judge.
All right. This is going to be marked as a probation violation, and accept the state's recommendation that he be given time served and that the case is administratively closed. Thank you.
Yes, we got add-on number 2.
Thank you, Your Honor. May I be?
Yes, Ms. Milton, thank you so much. Please email the documents to Ms. Grace, okay? Ms. Grace, thank you. Add-on position number 2. This is State versus Lamarvin Allen Harris, case number 22 CR 004-834C. Mr. Harris is accused of battery domestic violence from June 23rd, 2022. Mr. Harris, you've been advised of your right to remain silent. Your attorney is going to be Mr. Owen Lynch. And Mr. Lynch, I'm sorry, what was the announcement? How are we proceeding?
Judge, forgive me. So he does wish to accept the offer as proposed by the state, with one very limited exception, is that we were, and I don't know how Your Honor would view this, but we would ask the court to consider no violent or harassing contact rather than no contact. But other than that, he's in agreement with all the conditions in the plea as as I've related to him.
All right, I will consider this a non-negotiated plea then. So, Mr. Harris, I'm first going to hear from the prosecutor as to their recommended terms, and they may also possibly state the factual basis for their plea offer. And then I will hear from your attorney. I will then let you know what decision I make, keeping in mind that I also have the right to disregard the plea and schedule the case for trial. So,
Judge, I certainly don't want to slow down these proceedings, but I'm not sure whether I've made Mr. Harris fully aware of the implications of this turning into a non-negotiated plea. I think we were hoping to get something that was negotiated rather than
well, negotiated in its very clear form is that the state and the defense agree to all the terms of the plea. If there are any terms in which there is a conflict, then it becomes a non-negotiated plea.
And I understand that. May I just have a brief moment to
with the host, no problem. With the host, please place Mr. Lynch and 5 North back into a breakout, and we'll go to courtroom 2.
Your Honor.
Who do we have?
Your Honor, if I may, before he goes, the only issue that we're not agreeing on is the contact and the stay away. I don't know if the defendant will be more comfortable if he knows that the time won't be modified in any way, that part. Is that what the issue is?
Y'all can put it in the chat. I'm moving on to courtroom 2.
Understood, Your Honor.
Thank you. Courtroom 2, I'm sorry, who do we have?
Position 13, Miller.
Thank you.
You're welcome.
No, this is a negotiated plea, Judge.
Thank you. This is State versus Keith Miller, 20 CR 004-209E. Mr. Miller, you've been advised of your right to remain silent, and your attorney is Mr. Zach Finley. This is going to be a negotiated plea for a charge of simple battery from July 16, 2020. And Mr. Miller, may I place you under oath? Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. King or Mr. Segura? Yes. What is the offer, please?
It is 12 months to serve 26 days, credit for time served 13 days with the balance probated, FVIP, and no further contact with Dominique Noble, DOMINIQUE, last name NOBLE, and a stay away from 1447 Peachtree Street Northeast in Atlanta.
Mr. Finling, are those the terms, and do you stipulate to the factual basis, venue, and ID?
Yes, Judge, those are the terms we are agreeing to. Do stipulate the factual basis, venue, and ID. Judge, we would just ask that as finances are a big issue in Mr. Miller's life, if the probation fees could be waived for a period of time. Additionally, if once he completes the FVIP course, if he could be on non-reporting status, Judge.
I won't put him on non-reporting status, but I'm going to waive probation fees.
Okay.
All right.
Thank you, Judge.
All right. Mr. Miller, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And have you any issue with your attorney? Or are you satisfied with this representation?
Yes, ma'am.
Satisfied, right?
Yes, ma'am.
Just
Thank
keep your
you.
mask on and talk loud.
Thank you. And Mr. Miller, if you decide to accept the plea offer and plead guilty to this charge, you would have to give up your constitutional right to have a trial before a judge or a jury. That would include the rights to not be able to confront your accuser, examine witnesses, present your defenses, challenge the state's evidence, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Are you entering a plea knowingly, willingly, and intelligently?
Yes, ma'am.
How do you plead to the one count of simple battery?
Guilty.
Your sentence is 12 months to serve 26 days, credit for time served 13 days. Your time at the jail is complete, and you will report to probation next Thursday at 132 Mitchell Street in downtown Atlanta. Do you understand, sir?
Can you say that again, please, ma'am?
You will have to report to probation next Thursday at 132 Mitchell Street in downtown Atlanta.
Yes, ma'am.
You will need to provide your current updated address, phone number, and email. And while you're on probation, you need to complete a 6-month domestic violence intervention program at your expense. I'm going to waive your probation fees, but you're going to be required to enroll and start those classes within 60 days of being released.
Yes, ma'am.
Once you complete those classes, you will continue to report to probation until the rest of the 12 months are complete. At all times while you're on probation, you have to have no contact with Dominic Noble, to stay 200 yards away from her, and do not communicate with her in any way, form, or manner. You're also to stay away from 1447 Peachtree Street in Northeast Atlanta. Do you have personal belongings at that location?
No, ma'am.
All right, so then you have no reason to return to that location. That concludes this plea. Thank you. All right, Mr. Lynch, are we ready to proceed?
Come on, Mr. Jones.
Mr. Lynch?
Judge, I don't want to mischaracterize anything.
No, you're not holding up anything. Just let me know if you're ready to proceed.
If I was chatting with Ms. King, and I'm wondering if the position we're at is that the offer would be what the offer is, what he's accepted, and she would be willing to just leave that contact at the discretion of the court so we can go forward with a negotiated plea. I'm not sure if that's what her response meant, so I'll let her answer that.
Well, I can answer that, and that's
all right, Mr. Walker.
That's not going to be the case. We can pre-try the case a little bit more, try to go back and forth. I think I do have a resolution. So if
I'd love to hear that. I'm sorry.
We can put it in the chat. You can go to the next position.
All right, 5 North, we're still on hold. Courtroom 2, I'm so sorry. Who's your next case?
This is position 3 on the add-on.
Okay, thank you. State versus Quentin Jones, case number 22 CR 004837F. Mr. Jones is accused of battery from a July 22nd, 2022 incident. Mr. Jones, you've been advised of your right to remain silent, and your attorney is going to be Mr. Zach Finley. Mr. Finley, I don't have an announcement for this position. How are we proceeding?
This is not my case, I believe, Judge.
Oh, it's
Judge,
not
I think case 1 through 4 and 6 are conflict cases.
Oh, okay. Is that Mr. Lynch as well?
Yes.
All right. What were those position numbers again? 1, 3.
1 through 4 on the add-on and 6 on the add-on are all conflict cases.
Okay, 1, 2, 3, 4.
They were reset from Tuesday's calendar.
All right, that's right. And position 6 is also conflict. So position 5 is the only one that's not conflict. Is that correct?
Correct, Judge, and that's my case.
All right. Francois, we are waiting on Mr. Lynch to be available to handle position Mr. Jones. Do you have Mr. Timber in there?
He's on the screen, Judge.
Who is this?
Mr. Lynch is on the screen.
Judge.
Okay, Mr. Lynch.
So yes, I am here. I have not had a chance to speak to those individuals. I did have a conversation as regards to Mr. Harris, and I do think we have that resolved. So
do we have a plea for Mr. Harris?
Yes, Your Honor.
All right. Now, Mr. Lynch, before I move on to Mr. Harris, Francois, let's check on this. Mr. Lynch represents add-on positions number 1, 2, 3, 4, and 6, which is Gordon, Harris, Jones, Knox, and Stevens. Have you spoken to any of them, Mr. Lynch?
I do apologize, I have not.
Okay, no problem.
I do have one slight issue, which Mr. Knox and Mr. Stevens have global offers presented to them, to which they are represented by another attorney, which is Dennis Murphy. I'm happy to talk to those defendants, but I just wanted to say at the beginning, I'm a little uncomfortable.
Okay, let me see. Position 4 and position 6 are represented by Dennis Murphy, correct?
On other matters, I don't think he's been appointed on the instant case, but the offers that are proposed would include pleas to those other matters. I'm happy to speak to them about that, but it may present some issues as far as.
I'm only gonna let you speak to the ones that you've been appointed to, which is Gordon, Harris, and Jones. So you need to speak to Mr. Jones as well. Okay. Courtroom Two, we're going to have, the only case that's handled by the PDs on add-on is position 5, Timber Mims.
Miss Mims, yes, it's position 5.
All right, okay, she's a miss, so we're going to have to address her probably a different location.
Mr. Lynch, you can call my courtroom. The number is 404.
I'm writing.
612-2392.
2392.
And he's going to call very shortly. We're going to handle cases represented by Miss Helen or Mr. Finling in courtroom 2. Mr. Lynch, let's move on to position number 2, 5 North. We have Mr. Harris. Oh, was it 5 South? I think it was 5 North. Okay.
5 North.
All right.
Add on to 5 North.
Thank you. So as I've already stated, this is Lamarvin Harris, accused of battery domestic violence from June 23rd, 2022. In case 22 CR 004-834C. Mr. Owen Lynch has had a chance to speak to his client, and we're proceeding with a
Negotiated plea, Your Honor.
with a negotiated plea. For purposes of the plea, Mr. Harris, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Walker or
It'll
Ms.
be me,
King?
Your Honor.
Yeah. What
Yeah.
is the plea offer?
The terms are 12 months to serve 28 days, credit for time served 14 days, the FVIP, and no further violent contact, as well as an ADET.
No further violent contact with whom?
With Miss, my apologies.
Is that done?
Yes, Latoya Dunn, Latoya.
Thank you. All right. And Mr. Lynch, are those the terms to which your client has agreed? And do you stipulate to the factual basis, venue, and ID?
Your Honor, we do so stipulate. Those are the terms to which he has agreed. I did discuss his right to a trial and all the elements of the charge that he's faced with and some of the implications of a conviction for that charge. I would ask the court accept the plea as negotiated. Thank you.
Thank you. Mr. Harris, have you consumed any medication or alcohol recently?
No, amoxicillin, I don't think that would hinder anything.
All right. Well, have you understood the proceedings so far?
Yes, ma'am.
All right. And are you satisfied with the representation you received?
Very much so.
And if you decide to take this plea, just like your attorney explained, you would have to give up your rights to go back to court and have a trial before a judge or a jury to challenge this charge, which will include the right to confront your accuser, examine witnesses, have the state challenge the state's evidence, present your own defenses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
That's fine, man. I'm prepared.
And are you entering a plea freely, willingly, and intelligently?
Yes, ma'am.
How do you plead to the one count of battery domestic violence from June 23rd, 2022?
I guess they call it no contest or guilty or no contest with it?
Well, you're on a seesaw. So I've understood that the offer was for a guilty plea. Is that correct, Ms. King?
That is correct, Your Honor.
Okay. So how do you plead, Mr. Harris?
Oh, guilty.
I'm sorry?
Guilty.
All right. This is a guilty plea to a battery domestic violence charge. Your sentence is 12 months to serve 28 days, credit for time served 14 days. Your time at the jail is complete. You will be released within 24 hours and you must report to your probation office, which is at 132 Mitchell Street, next Thursday. Do you understand?
Yes, ma'am. And will they give me everything I need in writing or in paperwork?
It should be in your disposition sheet, but just keep in mind your Fulton County Probation Office is in downtown Atlanta. I'm telling you, remember, 1 week from today, you need to be in the probation office.
Okay.
All right? You'll be placed on probation to complete a 6-month domestic violence intervention program. You must enroll in that program within 60 days of being released, and you will be responsible for the cost of those classes. At all times, you're also to complete an alcohol and drug evaluation and submit yourself to any treatment if necessary as set forth by the provider. This alcohol and drug evaluation must be, you must enroll in that evaluation within 30 days of being released. Do you understand, sir?
Yes, ma'am.
And you must submit yourself to any treatment or counseling as recommended by the provider. At all times, you will report to probation. You are to have no further violent contact with LaToya Dunn. That means there cannot be any physical and or verbal altercations that might involve the police. Do you understand?
Yes, ma'am, very much so.
And Ms. Dunn, do you have any comments? You may unmute.
No, ma'am. Thank you very much. Can you give me that address again where he has to report?
132 Mitchell Street in downtown Atlanta. Next Thursday, which will be August 18th, before 3 p.m.
Before 3. Thank you very much.
Make sure probation has your current address, phone number, and email. That concludes this plea. Thank you, Mr. Lynch. Thank you, Mr. Harris.
Thank you, Your Honor.
All right. Okay, so 5 North, you don't have anyone else, correct?
Got number 12, Mr. Kelly on 5 South.
All right, 5 South, I'll be back with you shortly. Well, I think Mr. Lynch is talking to, you need to call the jail and talk to the folks at the jail.
He's waiting by the phone, Your Honor. He's waiting by the phone, waiting for Mr. Lynch.
All right, and Courtroom 2, I'll be right, you're on deck. I'm going to 5 South. 5 North, we concluded. Thank you. Okay, and who do we have at 5 South?
Number 12, Mr. Kelly.
Thank you. This is State versus Antonio Kelly, case number 22 CR 004-966C. Mr. Kelly was charged with battery from a June 23rd, 2022 incident. Mr. Kelly, you've been advised of your right to remain silent. Just to remind you, anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Zach Finding. This is going to be an arraignment and a bond hearing, understand?
Judge, this will just be an arraignment only.
Okay. Do you waive a reading of the accusation?
I do, Judge.
Mr. Kelly, you've been accused of 1 misdemeanor offense of battery. Upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the state has the complete burden to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the state prevails, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine for the offense. How do you plead, sir?
I want to take the guilty plea and what was offered to me for the guilty plea.
All right. Have you spoken to your attorney about?
I have.
Okay. All right. Mr. Kelly, I know yesterday we spoke. You said you wanted to plead not guilty. So if you want to move forward with a guilty plea, is that right?
I do.
Okay. All right. If I could please be put in a breakout room.
Actually, I can reset the case out to next Tuesday or next Thursday because the offer is 120 days instead of 45 days. So it still has additional time.
Yeah.
At the jail.
Yeah. If we could do that, Judge. I did speak with him about the offer yesterday, but I would feel more comfortable with more time.
Okay. The case is going to be reset to next Thursday, August 18th.
Got it. Thank you, Judge.
All right. Mr. Kelly, as this case is, as you are going to have to go over the terms of the plea, as well as sign off on some documents, I'm going to reset the case to August 18. This will not prejudice your plea offer, as the recommendation requires you to serve additional time at the jail. So this additional time will count towards the credit.
Okay.
All right, we'll see you on August 18th. Thank you. Courtroom 2, do we have?
Your Honor, quick
Please.
question. Who's gonna be representing Mr. Knox, Danny Knox?
I'm gonna be in here for a while, but I ain't fighting my feelings.
Is it gonna be?
Danny Knox, is that
It's on the add-on.
K-N-O-X?
I believe that was Mr. Lynch's case as well, or no?
Danny, okay, let me just clarify. Danny Knox and Rashad Stevens are represented by Dennis Murphy. Mr. Murphy, as I can tell, is not on the Zoom conference today. So right now, Mr. Dennis Murphy has been appointed to, Mr. Dennis Murphy represents Danny Knox in his other cases. So Mr. Murphy is going to have to talk to Danny Knox
Okay,
because that is his attorney. And I'm appointing Dennis Murphy to also address this case.
okay, so is he gonna be reset or?
He's going to be reset to August 18th for Mr. Murphy to appear and talk to him about the case.
Got it.
Same announcement for Rashad Stevens. Dennis Murphy represents him in his other case.
Okay,
And also going to be reset for 8/18 for Dennis Murphy to address both cases.
okay, y'all.
Can I ask a question? Do I have a bond?
All right, who is speaking? I'm so sorry. Is that Danny Knox?
Yes, he wants to know if he has a bond.
Yes, I will tell him. For Danny Knox,
Come on, sit here.
all right, Mr. Knox, please remember, do not make any statements about your case. Because if you make any statements and your attorney is not present, you're not only going to incriminate yourself, but you're going to make it very difficult for Mr. Murphy to represent you. Do you understand?
Yes, ma'am.
And your attorney is Dennis Murphy. Your bond was set on July 26, 2022 by Judge Morrow, and your bond is $10,000 surety bond. All right, that is your bond. Okay, thank you. We'll see you on the 18th. With regards to Rashad Stevens, he's also going to be represented by Mr. Dennis Murphy. And for some reason, Mr. Rashad Stevens never had an initial appearance. So it was just an accusation. He has a companion case.
Judge, he's not holding on this case. He's holding on a felony charge. The case was just added to the SAP count because he's in jail.
Okay, all right, thank you. So who do we have in the chair right now?
Judge, we're ready back on position 3 to add on Mr. Jones.
Okay, thank you. This is Quentin Jones, again, case 22 CR 004837F. He's been already advised of his rights. And Mr. Lynch, what's the announcement?
So, Your Honor, I believe we're going to have a resolution on this, but I just need to speak to the prosecutor very briefly on the disposition.
All right, do you have another case, Courtroom 2?
This is our last case, Judge, in Courtroom 2.
All right, Mr. Lynch, that's the Courtroom 2 is holding on you and the prosecutor.
Is this Ms. King?
It is.
All
Okay,
right.
I'm going to just chat you something real quick and see if we.
Okay.
All right, while we are waiting for that resolution, do I have any cases in different locations of the South Annex or Union City?
Judge, if we can just give the other officers a minute, they still have to go to different floors.
Okay, I'll wait then. Thank you.
You're welcome.
Mr. Walker, if Mr. Howard is present, we can move on to the competency calendar.
I'm present.
Okay.
Judge Derek's on a trial. Oh, there he is.
Okay.
All right. Mr. Howard, is our social worker present too?
No, Judge, she's not going to be with us today, so I can just give the updates.
All right, thank you. Could the host place me and Mr. Walker and Mr. Howard in a Zoom, in a breakout room, please?
Grab my calendar, Judge.
Ms. Grace, while we're waiting, do we have a non-jail plea case in the courtroom in G33?
No, ma'am, we just got a DV calendar.
Okay, thank you.
You
And
want,
Judge, I'm ready for the DV calendar. I can ask that client to log on if you'd like.
No, I'm going to do my CC calendar first. So
Okay.
the host place Mr. Walker, me and Mr. Howard in the breakout, and Miss Grace can join us too.
Your Honor, Mr. Jones will be ready for a negotiated plea when you get back.
Okay, thank you. Mr. Jordan, Ms. Lewis? Oh, I thought they were ready for your case.
Mr. Lynch.
Yes, I'm here.
Yeah, what's your phone number? I call have Mr. Smith, Mr. Stevens holler at you. What's your
Uh, Yes, sir. My phone number. Can I put it in the chat to you?
That's fine. I'm on 4 North.
Okay.
All right, we are back with our main calendar, and we were going with Mr. Lynch's client who is in courtroom 2. And that's Mr. Jones, correct?
Yes, Your Honor.
All right. So, Mr. Jones, we are going to address a plea hearing. Is that correct, Mr. Lynch?
Yes, Your Honor, we have a negotiated plea.
All right. Mr. Quentin Jones is 22 CR 004-837F, accused of battery from July 22nd, 2022. Mr. Jones has been advised of his right to remain silent, and his attorney is Owen Lynch. May I place you under oath for the purposes of the plea, Mr. Jones? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. All right, Ms. King, what is the negotiated terms of the plea?
Yes, Your Honor, it's 12 months to serve, 44 days, credit for time served, 22 days with the balance suspended.
Thank you. Mr. Lynch, are those the terms to which your client has agreed?
Yes, Your Honor, he has agreed to those terms.
And does he stipulate to the factual basis, venue, and ID?
He does.
All right, thank you. Mr. Jones, have you consumed any medication or alcohol recently?
Not at all.
And have you understood the proceedings as well as your attorney?
Yes, ma'am.
And do you understand the waiver of rights in exchange of entering a guilty plea?
Yes, ma'am.
And is anyone forcing you to take this plea today?
Not at all.
If you decide to take this plea, as has been explained, you will need to give up your right to a trial before a judge or a jury, which will include the right to confront your accuser, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you willingly, knowingly, and voluntarily giving up these rights?
Yes, ma'am.
How do you plead to one count of battery?
Guilty.
Your sentence is time served. That concludes your case. Thank you.
Judge, what case was this?
This is position 3 on the add-on calendar.
Okay, thank you.
All right, Francois, thank you very much.
Thank you, Judge. See you later.
Yes, ma'am. Thank you.
All right, thanks.
4 North, who do we have?
Position number 1, Mr. Banks.
All right. This is State versus Chaz Javon Banks, 19 CR 009-214Y, accused of loitering and prowling, obstruction of an officer, and criminal trespass. Mr. Banks, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your attorney is going to be Mr. Zach Finley. This is going to be a negotiated plea. So for purposes of the hearing, may I place you under oath? Mr. Banks?
Yes, ma'am.
May I place you under oath for purposes of the plea hearing? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, Ms. King or Mr. Segura, what are the terms of the plea offer?
The recommended plea is 12 months to serve 365 days, credit for time served 359 days. Thank you.
And Mr. Findling, do we stipulate the factual basis, venue, and ID?
I do, Your Honor.
And this is the terms to which your client has agreed, correct?
That's correct, Judge.
All right. Mr. Banks, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
And are you entering this plea willingly, knowingly, and intelligently?
Yes, ma'am.
Your attorney has gone over the waiver of rights, including the right to a trial before a judge or a jury, to confront your accuser, challenge the state's evidence, present your defenses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
How do you plead to one count of battery? One count of loitering or prowling, obstruction of an officer, and criminal trespass?
Guilty.
Your sentence is time served. That concludes this case. Thank you.
And next we have add-on 6, Mr. Stevens.
Mr. Rashad Stevens, your case is 22 CR 005-161Y. You have been accused of disorderly conduct. First of all, remember you have a right to remain silent. Anything you say in open court, Your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. Dennis Murphy. Mr. Murphy is not available today. In your particular case, you do have a bond, you do have a release bond. So this particular case is not holding you at the jail. So we're going to reset your case to next Thursday, August 18, for Mr. Murphy to appear and represent you in this case. Do remember, this case is not holding you at the jail. You have a release order for this case. Do you understand?
Yes, ma'am, Your Honor. May I ask you one more question? What about the simple batteries that I had, or the simple assaults? I had a release bond on those too, ma'am.
Let me check and see.
Yes,
This
ma'am.
is, you are Rashad Stevens. You
Yes,
have
ma'am.
3 open cases in state court, all right? So let me check and see. Disorderly conduct, there is a release bond. You have another case, state court case ending in 22 CR
Yes, ma'am.
001597Y. Yes, you do have a release bond in that one. And that is a $2,000 signature bond through the jail.
Yes, ma'am.
All right, let me see. You have another open state court case, 22 CR 005161Y.
Yes, ma'am.
And let me check on the bond status. All right, and there is a release bond. The matter that is holding you at the jail is a $25,000 bond in the Superior Court of Fulton County, not in this court.
So all 3 of the misdemeanors, the prior misdemeanors, they released.
You don't have a surety bond. Those are released.
So they're not holding me at the jail, Your Honor.
It's your felony case.
All right, thank you, ma'am.
Thank you.
Say August 14th.
18th.
You said 18th. All right, thank you, ma'am.
Thank you.
All right, I'm away to 4 South now. Be right back on.
4 South, do we have a case?
Yeah, I gotta go over there real quick.
All right.
In the interim, Your Honor, I have a non-jail plea calendar with Attorney Hilliard. Both him and his client are on. I just forwarded you the paperwork. It is a negotiated plea.
Are you sure we want to deal with Mr. Hakeem Hilliard?
If
Are you sure?
If the
He's
court
got
would
a pass.
oblige, I know he's a
got a
very
pass.
busy man.
Good morning, Your Honor.
Good morning, Mr. Hilliard. It's a pleasure to see you again, sir. We used
Very
to be
good.
staff attorneys
That's right.
I
Very
heard
good.
that
before Mr. Walker was even born.
I heard.
That's right.
All right. All right, sir. We have a non-jail plea calendar, and let me go ahead and pull up the case, please. This is position number 8, case number 18 CR 006944G. This is State versus Timothy Jason Harris. And Mr. Harris, I do see him on the screen. All right. Mr. Harris, you have a right to remain silent about the facts of your case. Anything you say during the course of this virtual recorded proceeding, your statements can and will be used against you. You have a right to an attorney, and Mr. Hakeem Hilliard, who, despite what I say, is still a highly competent and very intelligent attorney, and he's going to be representing you, okay? All right. So we are going to attend this plea. We're going to do this plea hearing. Mr. Hilliard, is this going to be a negotiated plea?
Yes, Your Honor.
All right, thank you. Mr. Harris, if you please raise your right hand, I'm going to place you under oath for purposes of the plea. Do you solemnly raise your right? Thank you. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Thank you. All right, Mr. Walker. What are the terms of the plea, please?
Yes, Your Honor. Mr. Harris will be entering a guilty plea to 1 count of DUI alcohol less safe. The additional count will be null process in exchange to the guilty plea. To the 1 count of DUI alcohol less safe, the state's recommendation is 12 months to serve, 72 hours. Credit for time served, 72 hours. Balance probated, a $600 fine, 240 hours community service, risk reduction, ADET, and Victim Impact Panel. And there is no objection to non-reporting upon completion, Your Honor.
Thank you. All right, Mr. Hilliard, are those the terms to which your client has agreed? And if you have anything else to add?
Yes, Your Honor, he did agree to those terms and nothing else to add.
All right, and do you stipulate to the factual basis, venue, and ID of this case for purposes of the plea?
Yes, Your Honor.
All right, thank you. I'm getting some feedback from, I don't know whom. So Mr. Hilliard, could you place your Zoom on mute? Oh, thank you. It might be Mr. Harris. Mr. Harris, you've already heard the plea offer from the prosecutor, Mr. Walker. First of all, have you consumed any medication or alcohol recently? Oh, you need to place your screen on mute, unmute. All right. And have you understood the proceedings so far? Excuse me. And are you satisfied with the representation you received from your attorney? Are you entering this plea willingly, knowingly, and intelligently? And is anyone forcing you to take this plea today? As your attorney has already gone over the terms, just to reiterate, if you decide to enter a plea of guilty to the DUI alcohol less safe, you would have to waive your constitutional rights to go back to court, have a trial before a judge or a jury, to be able to challenge the state's evidence, present your own defenses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
And how do you plead to one count of DUI less safe, DUI alcohol less safe? Your sentence is 12 months to serve 72 hours, credit for time served 72 hours. You don't have any additional jail time, but you will have to report to probation, which will be next Thursday. And you might want to write this down. You will have to report to the probation office next Thursday at 132 Mitchell Street in Atlanta, Georgia. When you report to probation, you will update your probation officer with your current address, email, and phone number. While on probation, you will report to probation every month and pay the probation fees and charges. You will also pay a $600 fine, complete 240 hours of voluntary community service with any nonprofit agency that is not a school and that is not a religious organization. Do you understand, sir? Mr. Harris, do you understand? Yes, your Wi-Fi is not stable. I need you to say whether you understand the requirement to complete 240 hours of voluntary community service at a nonprofit agency. And it cannot be a school and it cannot be a religious organization. Understood? You also need to complete one risk reduction program, submit yourself to an alcohol and drug evaluation, and comply with any treatment that's recommended by the provider. You will also attend one victim impact panel that will be instructed by the probation office. Once you have completed all these conditions, your probation will then be non-reporting. All right. Mr. Hilliard, any questions?
I do not have any questions, Your Honor.
All right. Mr. Harris, if you have any questions, you may defer them to your attorney, okay?
Judge, I got a quick question.
Yes, sir.
Is this a first or second DUI?
It's the second.
Thank you.
All right. Thank you. Mr. Hilliard, it's very good to see you and good to see that you're safe and healthy and all in one piece.
Likewise, Your Honor, you made my morning to get a chance to see you. Thank you very
All
much.
right. Take care. Good
All
to
right.
see you. Take care. Mr. Harris, thank you very much. This concludes the case.
Judge,
All right. I have one case at 4 South, and who am I addressing?
Judge, I have position 4, Mr. Bowen.
All right. Thank you.
I gotta go down to
This is Stephen Bowen, case number 19 CR 002-417Y. Mr. Bowen has been accused of criminal trespass, domestic violence. And Mr. Bowen, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Zach Findlay. Mr. Findlay, if you, sorry, let me just go ahead. This is position number 4, and this is going to be an arraignment, correct?
Yes, Judge. This is just an arraignment. I went over the plea with him yesterday. And
All right. And do you waive a reading of the accusation?
yes, Judge.
All right. Mr. Bowen, you have been accused, excuse me, I'm so sorry. You have been accused of this misdemeanor offense. You are legally presumed innocent of this charge, and upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the state has the complete burden to prove the charge against you beyond a reasonable doubt. If the state does carry its burden of proof and you are convicted of said offense, you could be sentenced to up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
All right. The case has been arraigned and further notice for jail jury. Thank you. That concludes this case. For South, do we, I guess, all right. Miss Helen, you said do we have any other cases at 4 South?
That's all I had on 4 South, Judge.
All right, thank you, sir.
Judge, I'm waiting on Cobb County to call in because I have one from Cobb County, and then I'm also waiting for Miss Mims from South Annex. She's position 5 on the add-on.
All right, South Annex, do we have one DB bench reset? Was that from Cobb County?
I don't believe it was a DB reset. She was just on the regular SAP calendar.
Okay. All right, just let me know when your Cobb County case chimes in, and a South Annex or whenever you chime in as well. I have a DB bench warrant matter.
Yes, Judge, and I believe she's logged on.
All right, this is State versus Cecilia. All right, Anoku. Miss Anoku, if you can unmute your screen, please. Thank you. All right, thank you. This is case 22 CR 003-034H. State versus Cecilia Anoku. Ms. Anoku was accused of simple battery domestic violence back on May 17th, 2022. There was a court date scheduled before Judge Taylor on July 28th, 2022, at which time Ms. Anoku did not appear and her bond was forfeited and a bench warrant issued on August 5th, 2022. On July 28th, 2022, excuse me. Ms. Anoku has filed a petition to set aside the bench warrant as a result of this failure to appear. Ms. Anoku, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Ms. Catrice Helen will be representing you. All right. So presently, Ms. Helen, what is the reason to set aside the bench warrant?
Yes, I've spoken with Miss Cecilia. She received 2 notices from the court. I have forwarded the one notice that I received from Miss Cecilia to Miss King, stating that this case, a battery simple, was reset to August 4th. So she received that notice. She even called their probation officer saying, hey, I received 2 notices. What should I be doing? And the officer said, hey, at this point, just make sure you make it to the August 4th court date. Well, Judge, when she went to the court, they had no record that this had been rescheduled. So I just sent that notice to Miss King. When I spoke to Cecilia, she's pretty much done everything, not pretty much, she's done everything that she needed to do. She updated her address August 5th. It's been the same address of the 7462 Spoleto Loop, Fairburn, Georgia, 30213. The same address from this case, Judge. So we are asking for this bench warrant to be set aside. She's currently working full-time in a Decatur nursing home. To have herself turn herself in for this FTA that she had no knowledge of, or excuse me, Judge, that the knowledge she did have was a reset to August 4th.
Okay.
And she did her due diligence, called the probation office, even called the clerk's office.
Right.
At this point, the notice that they gave her, hey, we don't have any notice for August 4th. We have that you missed July 28th. And so Miss Cecilia has done everything she needed to do. She appeared, she spoke to me, and she spoke into her probation office, the clerk's office, to try to be at her court dates, Judge. But today I have an updated phone number. I have an updated email address. I have just a current address that she's already had on file. And we are again asking for this bench warrant to be set aside.
All right, Ms. King, any objection to setting aside the bench warrant?
Under our office policy, yes, Your Honor, due to the facts of the case and the charge, I am reviewing the documentation.
Well, I'm sorry not to cut you off, but I just reviewed it, and that's not Fulton County. That's from municipal court. So perhaps she has so many cases, she got her cases confused. But the notice that you sent us is from a municipality, not from Fulton County State Court. So that's not a reason for her to miss her court. That's just indicative of she has so many cases, she can't keep up with them. So with that being said, we would ask that the bench warrant remain the same. That's not a valid reason because you got a notice from another court for another case. I'm sorry, that's her mistake, not ours.
And so, Judge, as I've informed you, she did all that she could, her due diligence, to follow through with the notices that she did receive. When I spoke to her, she did not know that this is from a magistrate. She believed that this is for this case.
Not a magistrate, a municipality court.
A municipality, Your Honor. So I've spoken to her. She's done her due diligence to be here today. She tried on several times to figure out which court date. So, Judge, we are asking for that bench warrants to be set aside.
All right. I'm going to set aside the bench warrant, and if she's going to be reinstated to pretrial services, and this was a domestic violence matter. So, Miss, I don't know if she's done the one-day anger awareness program. I'm modifying the bond. She's going to do an 8-week anger management program at her expense. And she must do so within she must begin those classes within 30 days of this modified bond order. And she will continue to report to pretrial. Her bond still remains at $4,000 signature bond through pretrial services. All right. So Ms. Anakwu, if you could please unmute your screen. Mr. Nakwu, please unmute your phone.
Miss Cecilia, just press the microphone. It should unmute your device.
I did. Hello.
Okay. Hello. Yes, Mr. Nakwu.
Yes, ma'am.
Based on the information we've been provided, this is not a confusion in court dates. It appears that you have other open cases or another additional case, and it's just in a different court. So it is your responsibility to read the entire notice from top to bottom to understand which court you need to go to, what time and what day. There is no confusion with regards to your failure to appear before Judge Taylor. So at the present time, I'm going to give you the benefit to set aside the bond, the bench warrant. So in other words, you will not be arrested. Do you understand?
What did you say again, Your Honor? Please. Do you mind repeating it, please?
I'm going to repeat it, but please pay attention.
Okay.
You did not show up in Judge Taylor's court because you got confused about which courthouse you had to go to. This is a result of your failure to read the notices correctly. Do you understand?
I'm listening. Yes, ma'am.
I didn't ask whether you're listening. I'm asking whether you understood what I said.
Yes, ma'am.
You did not read the notices correctly. It is your responsibility to understand which courthouse you need to be on which day and which time. Do you understand?
Yes, I understand. I'm understanding it.
And I'm going to give you the benefit and I'm going to set aside the bench warrant, which means you will not be arrested today. You will continue to report to your pretrial officer. You have a $4,000 signature bond through pretrial. Do you understand that you're required to report every month?
I've been doing it.
Okay, and you should continue to do so.
Yes, ma'am.
As a condition, I am modifying the bond to require you to do an 8-week anger management program.
Yes, Honor.
You must start that program within 30 days from today. And you will go to a qualified anger management school and pay for those classes yourself. Do you understand, Ms. Anokwu?
Yes, ma'am. Yes, Honor.
And this is for this case. Keep track of which case you're doing it for. Keep track of the case number.
I have a question.
Yes?
Your Honor, this is the letter.
Oh, wait, Miss Cecilia, if you have any questions about the law or anything we discussed when I've spoken to you, we can talk about that. But the judge cannot advise you on your notices. She is telling you it's your responsibility, okay?
Okay. Yes, ma'am.
And Your Honor, I know you made your ruling, but
Yes, ma'am.
just because I just received the notice that was sent, just FYI, it was for another battery case.
Understood. And that's why I'm imposing the 8-week anger management. Right. And today, since she did not appear at her plea and arraignment, Ms. Helen, shall we do an arraignment now, or would you like to file a waiver of arraignment?
I'll file a waiver of arraignment, Judge.
All right. We're going to deem this case to be arraigned. Ms. Anokwu, your case is going to be scheduled for trial before Judge Taylor. Do not miss any future court dates, otherwise a warrant will be issued again for your arrest.
Thank you, Your Honor. So there will be no more, it will not be on the computer anymore.
Miss Cecilia, I'll give you a call after this court appearance, okay? I got some questions I'm going to answer for you, okay?
All right. Thank you very much.
Highly recommend you speak to Ms. Helen because you need to understand what's going on.
Yes, Your Honor.
All right, Ms. Helen will expect a waiver of arraignment in this particular case and will be further notice for trial before Judge Taylor.
Yes, Judge.
Thank you, Judge.
Thank you.
Thank you very much.
You're welcome. All right. Oh dear, something my eye there. Okay, sorry about that. Okay, South Annex, 3 South.
23, Mr. Wilson.
All right, and the host can mute Cecilia's eye. Oh, thank you. Okay. 3 South, and I'm so sorry. What was that name again?
23, Mr. Wilson.
Mr. Wilson, thank you. This is Miss Helen's case?
Yes, Judge, and that's a negotiated plea.
State versus Timothy Andrew Wilson, case number 22 CR 005-208G. Mr. Wilson, you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Catrice Helen. This is a case in which you were accused of fair evasion and possession and use of drug-related objects from an August 1st, 2022 incident. Understand that you're going to this is going to be a negotiated plea hearing. So may I place you under oath?
Yes.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. All right. Miss.
It's me, Your Honor.
Yes. All right. Sorry.
No problem at all.
What's the terms of the offer?
It is time served 5 days with the balance suspended. No, time served 5 days and a stay away from the MARTA station located at 435 West Peachtree Street, Atlanta.
Is that the West Peachtree MARTA station? Or
that's what I'm confirming now, Your Honor.
I apologize. Can I have that address one more time?
4,
435
go ahead.
435 West Peachtree Street. Trying to find the.
All right, and while Ms. King is confirming the location of that model station, Ms. Helen, does
Yes,
the
Judge.
warrant stipulate to the factual basis, venue, and ID?
I do, Your Honor.
And does he accept the terms as negotiated?
Yes, Judge.
All right,
It is the Civic Center Model Station, Your Honor.
Civic Center, okay. All right. Mr. Wilson, first of all, have you consumed any medicine, medication, or alcohol recently?
No, I haven't.
And have you understood the proceedings so far?
Yes, I have.
Are you satisfied with your attorney's representation?
Yes, I am.
And are you entering this plea willingly, knowingly, and voluntarily?
Yes, I am.
And do you also understand that if you take this plea, that you will have to waive your constitutional rights to go back to court and have a trial in front of a judge or a jury? You will not be able to confront your accuser, examine witnesses, challenge the state's evidence, present your own defenses, and have the state try to prove the charge against you or charges against you beyond a reasonable doubt. Are you prepared to waive all these rights?
Yes, I am, Your Honor.
How do you plead to 1 count of fair evasion and 1 count of possession and use of drug-related objects?
Guilty, Your Honor.
Your sentence is going to be time served with the full 5 days you've been at the jail, and you are to stay away. In other words, you can legally use the MARTA trains and MARTA buses, but you cannot get off or start at the Civic Center MARTA station. So you cannot be anywhere within that vicinity. You might also want to check with MARTA if there are any outstanding suspensions, because that suspension will require you to stay away from all MARTA services until the suspension expires. So in order to avoid any future problems, check and see if there's a suspension, and if not, you've got to stay away from the Civic Center MARTA station at least until any suspensions are lifted. Okay?
Yes.
All right, thank you. That concludes this plea. Ms. Grace, please make a note that he's to stay away from the Civic Center MARTA station in accordance with any suspension. All right.
Okay, Judge.
Thank you. All right. 3 South, do we have another case?
Off.
All right, we'll wait for the officer to appear at 3 South. Do we have any other cases at 3 South?
No, ma'am.
All right, thank you, sir. South Annex, do we have any cases? All right, I'm just going to go over the calendar on the probation revocation matter. That was credit for time served and the case was closed. The competency calendar has already been addressed. The DV bench warrant calendar, Ms. Helen will be submitting a proposed order setting aside the bench warrant and amending the signature bond through pretrial to require an 8-week anger management class to be completed at the defendant's expense. And she will also be submitting a waiver of arraignment, so the case is further noticed for trial. With regards to the add-on calendar, position 1 Banks, excuse me, that's a regular add-on calendar. Position 1 Gordon, that case has not been addressed. That would be Mr. Lynch's case. Mr. Lynch, I do not know where Gordon is, Kendrick Gordon.
I believe the deputy may have informed me that it was a quarantine issue and they would have to come at the end of the calendar. I think that was what I understood.
All right, we can wait till the end of the calendar to see if Gordon is brought in. Otherwise, I have to reset him to August 18th. Have you had a chance to speak to him?
I have not, Your Honor.
Okay, so let's see what happens at the end of the calendar. So I still have one more case at the South Annex, okay?
Thank you.
Position 2, Harris was a plea. Position 3, Jones was a plea. Position 4 is reset 818 for Mr. Murphy to appear. Position 5, Timber Mims, we are waiting at the South Annex to see if Timber Mims will appear. And that's Ms. Helen's client, correct?
Yes, Your Honor.
Okay. Position 6, Stevens, is reset August 18th for Mr. Murphy to appear. All right. On the main calendar, position 1 was a plea, Banks. Position 2 was arraigned and further notice for trial. Position 3 is reset to 8/16. Position 4, Bowen was arraigned and reset jail jury. Position 5 and position 16 is jail jury. Mr. Finling, are you filing a waiver of arraignment?
Yes, I am, Judge.
All right, so that's for position 5 and position 16. This is going to be a waiver of arraignment and further notice jail jury. All right, thank you. Position 6, gun, is a jail jury, so this is going to be a waiver of arraignment and a jail jury.
And Judge, sorry to, but number 5 and 16 is Miss Helen's, just so you know. So she'll be submitting that waiver, but number 6 is mine, and I will be submitting that waiver.
Correct, Judge. Position 5 and 16 have already received the waiver of presence and arraignment to Ms. Graves.
All right, thank you. Position number 7, I have reset. Mr. Finley, you sure you want to reset them? I can just, you can, okay.
Which one's that, Judge?
Harris, this is the second case where the client refused to speak to the attorney.
I know. I know. Maybe it's wishful thinking that they'll eventually meet with me.
Okay. Position 8, reset 8/18. Position 9 was arraigned and further notice for trial. That was Hudson. Position 10, Jennings, was a plea. 11, Nathaniel Jones is released. So this is further notice for trial. Position 12, and Kelly was reset to August 18th for a plea. Position, now, was that Mr. Finling's case? Yeah. If Mr. Kelly decides to change his mind again on the 18th and wants to have the case arraigned, please consider filing a waiver of arraignment.
Okay.
All right.
We'll do, Judge.
All right. Position 13, Keith Miller was a plea. 14 was arraigned and further notice, bond amended to 2,500 surety. 15, same defendant, bond amended to 1,500 surety. Position 16 has been addressed. 17, Richardson was a plea. 18, Robinson was a plea. 19, Tyrone Robinson is arraigned and further notice for trial. 29, Satterwhite is a plea. Excuse me, not 29. 20, Satterwhite is a plea. 21, Sheridan, Dean Sheridan. What are we doing?
We're still holding, Judge. That's the case from Cobb County.
Oh, okay. Ramona White is 22, and that's going to be a felony transfer. Have I signed the felony transfer order?
Not yet, Your Honor. We're still waiting from the DA's office to officially accept it, but it's under the recidivist statute, so it will be on Your Honor's desk soon.
Okay. Position 23, Timothy Wilson is a plea, and that's it. We are waiting on position 21 from the SAP calendar. Position 1 and 5 from the add-on calendar. Okay, so Mr. Lynch, I don't have any more updates. None of the locations at the jail indicated that they were bringing anyone else. What would you like to do with Gordon?
Well,
Gordon.
you know, I haven't had a chance to speak with Mr. Gordon, so, you know, I'm willing to wait as long as it takes, or if the case needs to be reset, then I'm sure I can make the reset date. I haven't had a chance to address his case one way or the other with him, Your Honor.
All right, we're gonna reset it to August 18th. I don't have any more space on Tuesday. And you would have to speak with your client, either visit him or, I don't know, does the jail do Zoom, Mr. Finley? To confer with the clients?
I have only met with clients in person, Judge.
So you go down and speak to them in the attorney-client rooms?
Yes.
All right, and do you do that the day before the hearing?
For SAP, yeah, Miss Helen and I, we meet with them generally the day before.
All right, so Mr. Lynch, that's what you'll have to do on the 17th, unless you meet them sooner than that.
Your Honor, I'll do everything I can to make sure I meet with him prior to the
Okay.
date.
So Kendrick Gordon is reset to August 18. All right, moving on to Miss Helen, the only two remaining cases are yours. I have Kahinde, I'm sorry, Miss Pamphile.
Yes, Your Honor. Good
Okay.
morning.
Good morning. You would have to
Yeah.
speak to Attorney Derek Howard.
Right, and I'm attempting to contact him, but he has not responded.
Okay, we've already addressed those
Right.
cases, and he will be able to give you an update with regard to that case. All right?
Okay.
But
Okay, Your Honor, thank you.
that case is reset to September 1st
Okay.
at 11 a.m. All
Okay,
right?
thank you. Thank you,
All
Your
right.
Honor.
You're welcome.
Okay.
All right. South Annex.
Judge,
Yes, Miss Grace?
what did we decide on the competency calendar with position number 3?
That would be Blackwell, and that is Mr. Howard is going to submit a modified bond order, signature bond through the jail, and to stay away from the incident location.
And
Okay.
to report to Gateway.
And to report to Gateway, yes.
Okay, and then one more, Sydney James 13 through 16. Are
They're
all of them gonna be
all reset
Are
to
you
August
gonna send-
18.
Okay, so you're not sending the null process,
That's correct,
No.
Ms. Grace.
No,
okay.
we're gonna hold off till August 18.
18th, okay.
All right. Okay, Miss Helen, what's the status with Cobb County?
I'm not sure, Judge. When I log on, normally Cobb County has the link. So this is a time served deal. So I'd like to see if we can get Cobb County on the line for Mr. Dean.
Can you reach out to whoever you would, or whoever we had sent the information? Because I don't know who I am waiting on. I mean, all I'm told is Cobb County, but am I waiting on a specific, am I waiting for the jail at Cobb County?
Correct, Judge. So let me see if I can contact my supervisor to see how we can get Cobb County on the line.
All right. And Mr. Jordan, can we confirm with South Annex that they don't have anyone else? Because we're waiting on Miss Helen's other client, Timber Mims.
I'll check with, give him a
Thank you.
note.
All right, we'll be in recess until one of the attorneys reports to me about Cobb County, and Mr. Jordan gets the status from South Annex.
Hey, Judge, I have announcements for position 21 as well as the add-on position 5.
All right, great. Thank you. Okay, thank you.
I'm asking for a one-time reset to the 18th.
All right, for position 5 on the add-on.
Correct. And 21?
Yeah. Reset to the 18.
Correct, Judge.
And position 21 on the regular calendar for Mr. Dean Sheridan is reset to August 18th.
Correct, Judge.
Would Cobb County Jail have to chime in on the
You'll
18th?
have to, and I contacted Derek. We'll just have to make sure Cobb County is on the line, but Mr.
Okay.
Sheridan is in Cobb County.
All right, and if you can share the contact information with Mr. Michael Jordan, we can help facilitate that if possible.
Thank you, Judge.
All right. All right, folks, that, okay, Mr. Lynch, that concludes our calendar then. Thank you, everyone. Y'all have a great week and we will see you later.
Thank you, Judge.
Thank you, Judge.
What happened with position 22?
Ramona White is going to be a
Felony transfer.
Okay, but no paperwork.
Yeah, we're waiting on Miss King to send us the order.
Okay.
Okay? We good?
Yes, ma'am.
All right, thank you.
Thank
All
you,
right,
Judge.
we'll resume at 2 o'clock for the C calendar. Thank you.
Thank you, Judge.